Welcome to the first Tompkins Talks of 2021. It's time for another summary of a recent case in a short, snappy way that's easy to digest, whether you're at home, in the office, or on the move. Today, I'm going to talk about the case of FCA and Arch Insurance UK Limited and others. So let's get started with the backstory. There have been lots of reports in the press about this case, which was brought by the FCA to seek to give clarity to businesses as to the cover available under insurance policies due to COVID-19. 8 insurers participated, with 21 sample policy wordings being reviewed. Given that COVID-19 has meant that many tenants have been unable to trade from their premises but obliged to continue to pay the rent, and many landlords have not received rent payments as usual, the case is of great interest to both landlords and tenants. Before talking about the Supreme Court's decision, a quick reminder as to the types of insurance policy which are likely to be relevant for landlords and tenants. First, loss of rent cover. This forms part of the landlord's building policy, and a landlord can generally claim if a tenant can't occupy and the lease provides for rent to cease during this period. This type of clause usually requires physical damage by an insured risk. Second, business interruption policies. These are invoked when the tenant can't occupy but must continue paying rent. Whilst physical damage is often required, some policies have extra cover for notifiable diseases or loss of access due to regulatory restrictions. This case was about the second type. Although COVID-19 is a notifiable disease, insurers have refused claims because businesses could not prove they were unable to occupy due to a particular COVID case, and/or there was no legal requirement for premises to shut. So what was the outcome? Well, the decision has been widely reported, with the case being fast-tracked to the Supreme Court given its importance to businesses across the country. As you may well have seen, the Supreme Court decided the case substantially in the favour of the FCA, meaning that businesses whose claims were declined may now be able to pursue them. A couple of key points from the decision are: first, policyholders do not need to prove that the business interruption was caused due to a particular case of COVID-19 to bring a claim, but rather they simply need to demonstrate that there were proven cases within the vicinity which caused the business interruption. And second, on access, policyholders do not need to show that the business interruption was caused by a mandatory rule of law and can rely on government's instructions being clear and carrying the imminent threat of becoming mandatory. The Supreme Court also confirmed that claims may be brought for partial closure of premises or an inability to use them for discrete activities. So what does this mean? Well, it's very good news for policyholders. Whilst every policy turns on its wording and needs to be considered carefully, the general message from the Supreme Court is that insurers should be paying claims promptly. As such, landlords and tenants should carefully consider the wording of their business interruption policies to see if cover might be available. Now, whilst the court did not consider claims under loss of rent policies, this decision will be helpful in interpreting what insured risks are for a claim under this type of policy. Most rent cessor clauses in leases do require damage to a property to be triggered. However, if a landlord's loss of rent policy provides cover for notifiable diseases, and the landlord can claim against that policy, they will be under substantial pressure from tenants to set off those monies against any claims for unpaid rent. I hope you found the video useful. Please comment, like or share it if you have. I'll see you again soon for another Tompkins Talks.